The title of my presentation is When the Personal is Cultural and the Cultural is Political and the Political is Violent. I'm trying to connect some of the women's work and their willingness actually to be political within Africa and within the Middle East, and even at places where we think women are liberated, but they are not. America and Europe, but my focus is usually on Africa and specifically on the Sudan. And in this case, I focus on the Sudan because of the contradictions that are happening specifically in the law. The law goes cultural and then it else, and specifically when we do the constitutions, at some time, okay, when we talk about the personal, actually I'm not referring to a private, a dichotomy of a private and political, but wherever that personal is, it is sometimes communal. So the community is supervising that personal. And since it is supervised by the community, it is no longer just personal, it is also political. It is, gender politics are in there within that community, and also it spills into the area of laws and constitutions. Ever since I read Cynthia Enloe, I started to put on my feminist binocular to look at certain situations and to see if they're really talking about women. Most of the time I found out the Sudanese law is built for men, and women just happen to be there. So let us do some regulation, some organization of women, not because of them, not because of the women, but to make the place more comfortable for the men. And go back to repeating privacy, 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 because whenever you say privacy, people welcome it. However, that privacy became almost detrimental to women's rights, because privacy means they are locked up somewhere and everything is serve, and their rights are breached. So how do we balance that? How do we get this personal, yes, it is political, and what type of gender politics that we are willing to work it? Women have been willing to go to jail. They have been willing to go in demonstrations. Everything they could do, they would like to do, they would do it if they have to do it. However, the law always pushes back. So in this presentation, I'm trying to look at harmful cultural practices considered personal and specified as women's culture and should be left alone. I thank you so much. Civilized point. For me, I'm always crass. It's like, who cares where it started? It is bad, it should go. So let us work from here, from that it is bad. And then it goes. The second point is how such practices become public and the state pushed back when called upon. At least make a policy, not even a full law, but they fail. And then the relationship between religious interpretations and the law and their effect on the personal and the political. With every success that women achieve in overcoming cultural practices or give their opinion on an issue, religion moves to a stronger position and pushes back against women. So for me, it always became something, in the Sudan, it could include, instead of race, class, and gender, I will say race, religion, and gender, because of all the gender-based stuff. The law is gendered. a violence is violence based on gender. So with all this gender specific and the socio-political of the people, how do we work things around? So I here present some of something that is actually, it is not particular to the Sudan, but actually happened in the Sudan, how religion came into the law. Lisa Hajjar told us about 3 steps. Communalization, in which religious law is separate from the national legal regime. Some scholars believe that Sudanese people's culture was based on Islam, just because certain traditions existed side by side with Islam. So a clergyman in the 19th century in the Sudan thought that whatever the Sudanese people are doing, since they are Muslims, got to be part of Islam, or that they mixed it with Islam. So J.S. Trimingham noted that the Sudanese received Islam wholeheartedly, but through their unique capacity of assimilation, molded it to their own particular mentality. Escaping the formulae of theologians, they sang in it, danced in it, wept in it, brought their own customs, their own festivals into it, paganized it a good deal, but always kept the vivid reality of its inherent unity under the rule of one God. Here you immediately see how things have been mixed for Mr. Trim, because there was a dichotomy, if you will, where people would say, oh, this is not religion, this is a custom. They would do this custom that apparently is against Islam, and they go and pray. So their customs sits here, their religion over here, and they practice both, and not in a mixture. The second step is nationalization. The nationalization is a state in which the state incorporates religious law into the traditional legal regime. Up until 1983, the only law that was subject to religious rule and incorporated into the body of law was the personal status for Muslims, which is known as family law elsewhere. So non-Muslims were also left to their Abrahamic or ancestral religions. There are millions of women who are not Muslims. The system left them out. They will not legalize or criminalize or even supervise any tradition that is hurting women, which now South Sudan is really suffering from that sense of being left out of the system, of being part of the law. Oh, that is their tradition. We will take care of the Muslims. Those women live under worse circumstances, but hey, that is their tradition, right? We don't want to intervene. In the same way that the British were saying that, okay, we will leave your religion alone. We just want the cotton from the Jazeera scheme, or we want something from the land. The last step was theocratization, in which the national legal regime is based on religious law. This is where the Sudan is now. The Sudan is saying expressly that the source of law is Sharia. Sometimes they add Sharia and the customs of the people, but they don't tell us which customs. It is a custom that fits in their need to legislate against women. And we could start with the Constitution, the latest Constitution. I will leave the historical part of this. The latest Constitution was in 2005, and it was done in anticipation of the secession of South Sudan, which happened, of course. And that Constitution is saying, for example, sources of legislation in Article 5. Nationally enacted legislation have effect only in respect of the northern states of the Sudan, and shall have its sources of legislation, Islamic Sharia, and the consensus of the people. Number 2, once more, the rest of the country, especially the southern part and other places, were left, because they don't believe in Islam, left to customs, and they were not subject to any legislation. Even the Christians who lived, the Coptics, the Egyptian Coptics who moved into the Sudan, they are a huge part of northern Sudan. And they are actually living in harmony with the Muslims. My own hometown is populated by a large population of Coptic Egyptians. But we don't look at religion unless they are going to the church and we are going to the mosque. And I remember our neighbor, a Christian, changed when he comes to a funeral or to a aza, he would do al-Fatiha. Because he knew that al-Fatiha is not Surah al-Fatiha, it is a prayer for the person who died, which actually resembles what a priest would say over a dead body. So he said, well, it's something that they do. But that harmony between the people never resulted in the same legal system governing all of them. Article 15 of that constitution is titled Family, Women, and Marriage. So women is mentioned, but not men. Because here we want to say something about one. The family is the natural and fundamental unit of society and is entitled to the protection of the law. The rights of man and woman to marry and to found a family shall be recognized according to their respective family laws. And no marriage shall be entered into without the free and full consent of its parties. So you see here, this is a constitutional right. Consent to marriage is a constitutional right, since it is there in the Constitution. What does the personal status law do? A complete reversal of this. For example, a guardian may petition the court for permission to marry off a 10-year-old girl. And mind you, this law was made in 1991. It wasn't like something from a time. It's a now thing, 1991. So a 10-year-old girl, because maybe there is a benefit in that marriage. But they don't tell us what do they mean by benefit. Or how can a 10-year-old girl benefit from a marriage? Like they want the wealth of that man or something? Who said he was going to give it? So this is something that's against international law. And this is also one of the things that women are doing now, is bringing in international law that the Sudan has signed and ratified. So this is unconstitutional because a 10-year-old girl does not have a consent. Even if she consented, it doesn't count because she's a child. Marriage continues to be a contract between two men, because guardianship works in the sense that the guardian of a woman is a party to the contract, not the woman herself. For example, the man can have an attorney, can have an agent. He can give a power of attorney to someone to contract his marriage. A woman cannot give that power of attorney. Her guardian may give that power of attorney to someone in his place, contract the marriage in his place. So it continued with guardianship. The woman is not into the marriage, but after the marriage, she was left on her own. Go for a divorce or to do what's in. The guardian may contract the marriage of his ward and tell her later. So the idea of consent went out the window. He could come back later and tell her, and with the traditions that are there, or with the practices that are still in the society, it will be scandalous for a woman to go and sue her father. Although a couple of women did, but they were rejected by their communities because how dare you go over your father's will. Section 24 of the law, of the same law, allows a guardian who does not consent to the marriage of his ward to a husband whom he thinks is unsuitable to petition the court for annulment of that marriage. And the only bar to that petition to the court if the woman got pregnant from that marriage or a whole year has passed. So if you look carefully with those feminist binoculars, the woman wasn't there at all. It was the guardian and the husband. The guardian has an immediate right to call for the annulment, and the husband gets the benefit of, if she was 1 month pregnant, gets to keep the wife. And so, whenever you look at the personal status law, it's always like this. There is another part of the Constitution that says, the state shall protect motherhood and women from injustice, promote gender equality and the role of women in family, and empower them in public life. The same personal status law takes that away by stating, if a woman goes to work without her husband's consent, she is an ashes. Again, what do we use? Do we use the law or the Constitution, or there is... women were discouraged from taking certain jobs that they actually fought for, such as being judges, joining police force, and taking jobs as engineers at oil production. Men will be preferred, despite the fact that the Constitution, of course, there is the famous paragraph about equality, no discrimination by sex or religion or race or all that. But here, they will actually prefer men. Not only that, at one time, when education stopped to be free for everyone, women, specifically those who are going to the university, would take jobs in hotels, and they will take jobs in gas stations. But the wali, or the governor of the province of Khartoum, immediately issued the regulations that women should not take these, should not be hired in these jobs because it denigrates their dignity. And the question was, does it poverty that denigrate dignity, or work in a gas station? So women very quickly, including women who are with the government, started a constitutional case. So their first request was a temporary hold or stop on that part or that regulation. Well, the judge very quickly said, yes, we'll put a temporary hold and until we look into the case. The case was never looked at again. No one knows where the file of the case went. So when women went back and said, hey, we put a hold on the regulation, well, the owners of the hotels and gas stations said, we can't hire you because now we don't know when or who is going to tell you not to work, and we will be out of people like that. We have to go on council, in that case we are going to hire you. So the Constitution also said the state shall promote women's rights through affirmative action. You can say women cannot take such and such and such jobs. What kind of affirmative action are you going to apply? That was just a hoax. And the state shall combat harmful customs and traditions which undermines the dignity of the status of women. Also a hoax, because women's organizations 5 years ago sat down with government people, with the help of the Attorney General. They were going to draft a law for the protection of children. So women said, okay, we need a section on female circumcision to be prohibited and punished if practiced. Well, they said, well, the society is not ready. Well, the society is not ready for anything unless you are ready to do it, unless you seek it. So they said, fine. They drafted the section, gave it with a strong promise from the Attorney General and from the Legislative Council that it is in there. When they brought the law, it wasn't. The law was passed in one sitting of that Legislative Council. And then when they were criticized by international community, they started to do something with non-governmental organizations. Or with the governmental organization that is the women's union that they created to combat female circumcision. Fortunately for women, it has been fastly disappearing, both in Egypt and in the Sudan. I know about the numbers specifically in urban areas. It is almost extinct. Some rural areas still practice. They are admonished to practice what they call sunnah, because sunnah itself is not a sunnah. There is no sunnah in female circumcision, but they call it to get the protection of religion. When it is sunnah, it is religion. When the illiteracy or non-literacy percentage is over 50%, 55% in either country, you can always talk people into something that religion. God said this, and people would by that religion. I will give another example because I think we have some time for a discussion of this. In the criminal law, I have been bothered by one thing, which is about zina. It used to say that zina is a consensual act, and sodomy is also a consensual act. When these sexual acts are consensual, they are also crime. They have to be punished. And then they came to rape. So they said, well, the definition of rape is that it is someone who commits zina or sodomy without the consent of the other party. But how can you put these two together? Because here the buzzword is consent. And that is the difference between the two. But then you bring a consensual act and say, if this consensual act is without, no, it doesn't work that way. It's almost an oxymoron. Because if you sit down and interpret it and want to use that, it's a big hurdle to even make sense while you're talking about this. So also, after a lot of work by women who were also demeaned and sometimes called names by bearded men, they finally changed it. So they said, okay, it is not just the sexual act. It is also forcing an object into a man's rear or into a woman's sexual part. Okay, fine. And then they added, if this act has been committed under, by force and by intimidation and without consent, and the consent of someone who has authority on the victim is not considered the consent, and we were all fantastic until they did not repeal the third part of this one, and they said, well, whoever commits rape will be flogged 100 flogs or go to jail for 10 years, unless that rape constitutes zina or sodomy, which is punished by. But how can it constitute a consensual act while it is non-consensual? How are you going to argue that? unless you want to deprive the woman actually from saying that it was non-consensual. It was rape. The idea is that, for me, the idea, when I put those binoculars, protection for the men who commit rape. They are not going to be, because if they said, well, it was a consensual act, okay, if he is not married, he is going to have to be flogged. But when they come in, they say, raped who? Had sex with who? I've never seen her in my life. And they are let go because there is no other evidence. So the trick is to tell the women, once you go in there, tell them that you were raped. And if they ask you to name the man, he will be dismissed from the investigation, because he will say, I didn't do it. Then you are the one who is going to be punished for that as a consensual. Fortunately, that worked, because there is the old English rule that you have to take, if a woman confessed to something, that you have to take that confession total. You can't say, well, no, I'm going to divide this and if she said it's not consensual, then that's it. And usually there is no other evidence for her to do. So it worked at the lower courts. There were 2 cases. One was for execution, because the woman was married, but her husband wasn't there. And the other one was for a young lady from South Sudan, 100 lashes. But the Supreme Court said, well, since the court didn't have any evidence except for this woman who said, if they say they're raped, then they are raped. And they let them go, but they spent like what? Months in jail to get to be free. So here the law is something against women rather than punishing men who had authority over. This is. I think I chose this one from the criminal law because there's a stark evidence. It just smacks you on the face that there's discrimination in this law, and that they are trying even to overcome what they call the traditions. The traditions protective of women. Sometimes those, we call them cultural practices, we call them traditions, whatever you call them. Most of the time, specifically in these cases, they are very protective of women. What we have to do with that? Everything else, oh, we can keep it because the society is not ready. Okay, for the protection of women, the society is ready. How come? They are not taking this readiness into account. And we see, that the distribution of power here, the gender politics, as we call it, is that the laws are made and the regulations are made are based in this gender politics, of which gender is usually the one that we want to organize and who benefits from that organization. Who benefits here is very important. And when we look at it with our feminist eyes, we see that men.
For discussions. I may start. Say a couple of things. I personally agree with you fully about family law. And the fact that they always combine women in the constitutions, they always put women with the family, always. And it's kind of ironic that the law does not even recognize the woman as being responsible for the children or for the family, and yet the Constitution combines the two together. So I think that's the biggest contradiction that you see consistently in most of the Islamic world, that the woman's role is dependent on the family. Therefore, you should at least recognize that in the law. You know, so I think that this is a place, an area that also needs to be expanded on and written more, as you have shown me very clear. I think the contradictions you've shown us are quite amazing, especially when it comes to the question of violence against women. How the law itself is a source of violence against women. And I think we haven't done enough work on this. And I think it should be flushed much more than that. Personal status law is the biggest enemy of women. And yet it's supposed to be the protector of women's rights. And that's an area as well that needs to be completely deconstructed. If we're putting an agenda of work, I think this is something that we should be looking forward to it. In thinking about something again that we discussed in our class, enablers. Who are the enablers? We always talk about the enablers. In this sense, I think the women are enablers, and I wanted to get to this in a minute, if you don't mind, because and this work has been done by, or is being done by European theologians, women theologians, who are trying to actually show the role of women in the construction of Christian patriarchy. We haven't done this. We've always looked at women as being, you know, victims, when in fact, and I'm trying to do this in the book I'm writing right now, and that is going back to the medieval period. I see the woman's role, whether it is vocal or is hidden, but in actual writing, in the construction of the patriarchal system we live by today. You know, and I think if we're talking about the agency of women, we should also see the agency of women as part of the process of the production of this knowledge by which we are actually ruled today. And I think this has been happening from very early on, and yet we don't take this as much, and it needs to actually be not just problematized, but also written about. You know what I mean? And, I don't know how we all feel about this. It's a very difficult subject because we don't have enough written by women, but there are a little bit of works here and there that one can actually.
Because we are always on the defensive.
Yeah.
So we try to show what women are doing, where their successes are.
In the past and in the present. But I'm trying to say that actually all along, historically, women have been part of this. You know, we always talk about Ibn Taymiyyah's teacher being, you know, this person and that person. I think some of the women you're highlighting, we're highlighting in the webpage, are also, you know, teachers, they're muftiyat and all the rest of it. So basically women have been party in the construction. And I think we need to do that, to write about them as part, not as saying the women did as part of the process of production. And I think this is part of the empowerment of women, giving them back into the historical narrative. And, you know, and the same today, because I think elite women today, and, you know, women who have you know, positions of power, who are related to men in power, are just as much of enablers as the men are. And that's, again, part of our, part of the dilemma that we see happening. Even NGOs, unfortunately, you know, many of the NGOs work for themselves rather than, that's okay. I don't see anything wrong with that. See what I mean? I'm part of NGOs, so I know that. But the point is, it's happening. And so we need to, somehow when we write, when we author, when we teach, show that this is an actual part of it and not separate the two genders. I have a problem with gender as a concept, you know, and as a paradigm to begin with, because I think it perpetuates itself. It perpetuates the problems we are talking with Dr. Asma. This is my personal feeling about this. You know, I will be talking about following up from you, actually talking about, you know, religion, power, state, and so on, but also class, and also the role of the clergy. That's what I'm going to be talking about. But I think this is very important, is to see it beyond just tradition. As you said very well put, that everything they find, they decide this is Islamic and they create into tradition. That's because it's familiar to them, and it's a discourse that they would like to dominate because it's comfortable. And I think that also is a very sort of thing that we need to be talking about. Yeah, Sharia and women. Yeah, I think that's something that also needs to There's a whole history there. I'm trying to flush out, but it's very hard. And he's about 100 women. So it cannot be done by one. I mean, each one of us can at least do a bit of it, a small bit at a certain part, and then they could.
A note on women and the family. I always wanted to discuss where are the men living? They are sharing that home. They're sharing the home, and the home itself is organized around them. So why is it always women in the home, women and children? And children have totally different rights than the rights of women, because they are not miniature adults, they are children. They have different rights. And the men, we always have to talk about men in the home. I don't think men are just leaving the home totally to women. They are responsible for paying inside that home. They are responsible for bringing up those children. They have a huge part in that family. And we just wanted to restrict. They don't sleep on the streets. They come and sleep at home.
I just wanted to bring in the question how effective laws actually are when cultural norms continue to dictate certain circumstances on women. And I think this ties into the larger debate on what is to change first, laws or culture and tradition. For instance, and this ties into my presentation, in late 2014, the first anti-sexual harassment law was passed in Egypt. And then in July 2015, an anti-sexual harassment initiative was able to capture about 340 harassment perpetrators. However, almost all of them were eventually released because only a few women actually showed up to the police station to sign off reports against these women in fear of stigma, their families, or disclosure of their information. So I think that even after laws are amended to ameliorate women's conditions, sometimes social challenges play a larger role in sustaining these conditions. And that's why I think working on the social and cultural mindset is as essential as working on laws.
Treating the question of domestic violence by the law, it's a novelty in the Arab world. I mean, issues related to violence within the family or in the public sphere were to a great deal, ignored or left to the family members or to the community to solve. Now we are witnessing a new trend of interfering. The state is interfering in the family dynamics. And this, is happening in Morocco. It started in Algeria, actually, then Tunisia, Morocco, and now Egypt, against the sexual harassment, phenomena in Egypt. And you talked about Sudan. But your intervention, revealed to a sort of, patriarchy here. It is not really Sharia, it is patriarchy,
Definitely.
Is this, that this came after the request of women's organizations or movement to urging the state to interfere in the domestic sphere, or it's, a novelty that is following the trend in the region? I just need to understand from where came this sudden interest of the state, to change the law and dealing with issues related to domestic violence.
The contemporary Sudan, just like anywhere else, is a patriarchal society. Totally, it is a patriarchal society. And as a patriarchal society, they intervened in organizing the home, starting, for example, from the 19th century, when the Mahdi said women are not to be seen or heard inside the homes. Don't want to see them. No public life, markets were closed for women, everything. Okay? Then we moved into the colonization era. Now it is continued in the name of Islam. What women are asking for is, let us talk about this patriarchy. Let us remove it. And then we can organize those families by alleviating all the patriarchal burdens that are on women. The state has always been there, organizing the homes and the streets and everything.
But is it about the Islamization now of the state in Sudan, or is it the new way of Islamizing, the law to protect women, or?
Right now, it is using Islam to continue the abuse of women, the violence against women, to just protect the perpetrators of the violence that is gender-based, and to clear the laws that the laws that are brought in are reminiscent of the 130 years ago. It's almost the same thing. You read, for example, the public order regulations in the state of Khartoum, the capital city. It's a horrible thing. There's something like that. Anyone who is dressed in a way that is harmful to the feelings of the people, okay, what kind of dress and whose feelings? And this, okay, the feelings of the religion that they belong to. Okay, if the religion I belong to is in Southern Sudan, and it allows me just to pull a piece of cloth tied up on my shoulder and walk on the streets. That is not acceptable in Khartoum, but is acceptable in the religion of the perpetrator, the person, the culprit who commit this. But it is allowed, right? So it is a draconian law, to put it simply, that wherever you turn it, there is a wide, huge thing that you will sit there and try to make sense of it, try to give it a legal sense, and you cannot. Whoever sings a song that is really harmful to the people, and guess what? There hasn't been a time that there has been bad songs in bad taste and awful dancing, except in this Islamic era, or like this Islamic era. Prostitution is rampant. Just a few days ago, in the newspaper, a businessman with a lot of money, he was bringing in girls of 12 and 13 years old to pleasure older men. It has never happened before in Islam, in Islam or in Sudan. But once they brought Islam in, they raised havoc. And this is what the women are talking about. You cannot bring Islam in to do all this and bring in all the restrictions, and you open the door for prostitution and for drugs and for all the things that the Sudan never heard of. But prostitution used to be known even as children. We won't go to that house. Okay? And that's it. No one is bothering the prostitutes in there. No one is bothering the men who are going in there. Right now, it is rampant, it is everywhere, and only poor women fall victim to these things. And this is why women are talking about, okay, let us talk Islam. Let us see the interpretations of Islam. Let us visit other countries. Let us have a conversation about this. But no, just this is the Islam that we want.
Yeah, I think this is a very important issue that this emergence of using Islam as, in discipline. I think it's not only in Sudan, but we have seen it in Yemen and many other countries. It takes different forms. In Yemen, it has taken the form that it's expressed in the way that our religion, Islam, says, listen, that, and then they pick the most backward issues from Islam, meaning that child marriage is motivated by Islam. But then at the same time, there's a debate, even among the forces that take Islam as the principal force in doing politics, meaning sort of Islamist politics. Even among them, there are disputes about that. Does Islam actually legitimate child marriage? And so these are the kind of points where progressive forces obviously have to sort of exploit and use. In Yemen, what the women's movement did actually as a reaction to this kind of using Islam as political reference only when talking about women and their sort of rights in society, but never about men. So what they did was that they said that, okay, if this is the framework where we discussed now, then we have to sort of educate ourselves about what exactly is there in Islam. And they sort of took the old hadith books and all that and started to take positive sort of support to their women's rights agenda. So what happened basically was that they rewrote the women's rights agenda from an Islamic perspective.
So many important issues to do with personal status laws. And I think it highlights everything we've been talking about so far, that on the one hand, as Susan just said, Islam is the stick used against women. On the other hand, it's also the counter stick, if you will. If we simply arm ourselves with the information and the counter interpretations that are out there. And this also goes to what you were saying about Saudi Arabia earlier. After the first discussion, we have to realize that we're dealing with a particular brand of Islam, that it is a modern construct, if you will, and that there are alternative sources of information. So just to talk about one of the points that you raised, which is actually the subject of a paper I'm writing right now, it's a very important point you point out about how personal status laws today prevent non-Muslim women from accessing the same laws in courts. And this is a very important issue and goes to what you were saying as well about gender being the trap as well. Effectively, this kind of a ban on non-Muslims prevents, and it's not just in the Sudan, it's throughout the Islamic world, it prevents us from meeting any standard of citizenship. Right? The fact that there is an absence of a civil law to which all can access means that citizenship is an impossibility. And this is something that only drew my attention because I remember during the revolution in Egypt, Coptic Christians were raising up banners in Tahrir saying, we want access to the Sharia courts. And I thought, why would a Christian want access to the Sharia courts? But it has to do with the problem of divorce in the Coptic Church, that, you know, it's impossible for a Copt, almost impossible to obtain a divorce. Whereas if they had access to the Sharia court, a civil court, if you will, they could obtain a civil divorce without having to convert outside of their religion. Now, when we study the past, one of the first things you'll be struck with Sharia courts in the 16th, 17th, 18th century is the fact that Christians and Jews accessed these courts alongside Muslims. So it's an interesting predicament yet again. So what does that mean? That we were closer to citizenship rights in centuries past than we are today in the so-called modern era? And what do we do with that information?
Yeah, it's usually the personal status law is very kind, and it says, well, this applies to all Muslims and whoever wants to come into this system. I remember two cases by two abused Coptic women. And what they did is they wanted this to apply to them because their church would not give them a divorce. So the only way to do it is to convert to Islam. And that would automatically break the bond of marriage. So what this is that declare their Islam, we are within this, our husbands, our lives, and they got a judgment on the same day. You are Muslims, despite the fact that I met one of them wearing a big cross after the divorce, and I said, they will kill you. Because there is a ridda law. Once you become a Muslim, they will kill you if you are a murtadda. She had to take it off. But she used part of the law to get out of what she was in. But apparently, as a Muslim now, if she married a Muslim man and she comes to this law, she's going to regret it.
Saying, it's interesting, goes back to what I was referring to before about Foucault, and where today when we talk about this Sharia law as applying, there's a history to it. So what she's referring to is that before the 19th century, the Sharia courts or Sharia was looked at as law, and it was open to everybody. The 19th century, what we see is the division. So there's Sharia for the Copts, Sharia for the Jews, Sharia for, actually, they recognize 7 different millahs in Egypt alone, that they would have different Sharias. See what I mean? And only if there's no law within their own Sharias would the Islamic law apply. So it also has again to do with organization of knowledge and how the knowledge was organized. And Sharia itself had a different meaning in 19th century and the period before.
And also addressing your point of modern interpretations, you heard Ruqayya mention a Sudanese thinker, Al-Ustaz Mahmoud Muhammad Taha. His main point is Islam is egalitarian. And let's talk Islam. And let us see how people are equal by reason of citizenship. That is found in Islam. How citizenship is that you can be a citizen of a different religion, but equal to the Muslim. There is equality between men and women in rights and duties. So let us also look, where did he end up? On the gallows. They hanged him, just for thinking.
I was just thinking, before we go for lunch, I was thinking of something quite different that my thoughts are leading to, and that is, okay, how are we going to break through all of that? I think it's being broken anyway, at least in a country like Egypt, which has become very chaotic, where a government cannot really control the population. What's really happening is that the culture of the base is taking over, and that traditions are changing so fast that what is being created is a system which is not necessarily egalitarian, which is built on violence, but in fact it's violence against men, violence against women, but where women have had to, and I think Nadine's paper will probably show this, that have had to be active, have had to find their own way. When you don't have family support, you don't have legal support, you don't have state support, and the only way you're going to get food for your kids, you're going to go out and work, even though the law tells you you can't work. So the point is, outside of the law, you have 104 million people today in a country that cannot feed 30 million. And so what do? So basically, there is a logic to chaos, I think. What we're looking at is chaos theory. I don't know, I'm looking at it. Don't have any answers. But I think change is happening already, and it's not just in Egypt, in most countries, that the traditions, and maybe this is why they're holding on to them so strongly. You know, the people in power, the clergy, those who are there, they want to hold on to the laws, and they're making the laws even harder, simply because really they're not really in control. That is, the culture has its own ability to metamorphose, to change, to mutate, you know, to create new traditions as we go along. And how do you control it? As a parent, after a while, you can't control your kid, you know, so why would you think that the state is going to be able to control society as a whole? They use aggression, they use, we all live in states that do that, you know, you are Big Brother is watching all the time, that was my say, and that any action is being weighed, or where the police is so drastic. So in a country like Egypt, that doesn't work anymore, because either you bribe or you kill or you do whatever. People are taking things into their own hands and just doing it. And I think this has to do a lot with the fact that women now are marrying much later, or not at all, choosing not to, divorcing on the spot, walking out of marriages and leaving their children to the husbands. That's why I think, I'm not saying this is a good thing, I'm just saying that we may be looking at, a shift that we need to ursud, to look at and study. And I don't think it's been, and it's the work of anthropologists, by the way, I think you guys should be doing this, that these shifts are taking place. Where are it going to go? I don't know. As we said, who is the new woman? Is she a harassed woman? Is she going to be an independent woman? She's going to be an Amazon in the future? I don't know. Of course, it depends on one country to the other. So it depends on I wanted to...
I think it's a huge shift, especially, for example, my mother is alive, and I am here, and we have kids at home. She is totally scandalized that people are ordering pizza. But the children are...
That's the best thing about modernity.
Yeah.
Is ordering
How could you
pizza.
eat outside the home? You have to eat at home. Eating in the market and ordering food made by someone you don't know. How dare you eat something cooked by someone you don't know? And you see the children, and the children are totally amused with her ideas, and they call it food cooked by someone you don't know. We ate food that's cooked by someone you don't know.
That's an indication that your mother comes from elite background, because I'll tell you, in old Cairo, most of the food, there were no kitchens in the houses. If you read Nelly Hanna's book about Cairo, which is an amazing book, she'll show you that most of the houses did not have kitchens, and that people bought from sellers. The market, this idea of buying in is very Middle Eastern. They actually, except for the rich homes, they're the only ones who actually had kitchens. But otherwise, most families, they bought from mendicants or people who passed through or went to the marketplace. So, yeah. Okay, well, thank you very much. I think we can have lunch now and then come back. Thank you, Dr. Asma. This was wonderful, really. Okay, our next speaker is Ramadan Al-Kholi, and he will be speaking in Arabic, so I hope that's okay. Let's go, Ramadan. And by the way, Rugaya has volunteered to translate if need be.
أنا فرادي بتكلم عن العنف النفسي ضد المرأة في مصر في الفترة العثمانية واستراتيجية. بس لازم الأول أقول إني أنا اهتمامي ما كانش بالعنف ضد الستات، أنا اهتمامي السنة اللي فاتت إن أنا بكتب عن طلاق. بس شفت حالات في الفترة العثمانية، وشفت حالات من مصر ومن القدس حالات ضخمة جدا، لكن في وسط الأوراق اللي كنا بنبص عليها كنا بنلاقي حالات وثائقية احنا الحقيقة مش عارفين، يعني أنا شخصيا ما كنتش فاهم، يعني بقول في حصل خطأ في الكتابة أو حاجة مش مظبوطة في الكتابة. لما الدكتورة سنبل طرحت عليا إن في ورشة عن العنف، قلت طب خليني ارجع شويه ابص على الاوراق اللي انا مش فاهمها قوي دي، اللي انا شايف ان ممكن يكون فيها خطا، بس بعد مراجعه الاوراق انا اكتشفت ان المساله اعمق بكتير.
Yes, we know this horrible room. You're not the only one. This is our problem in life for all the faculty here, is this room. Why don't you come and sit with us on the table? We have enough room. I have a chair right next to me, so. Speakers, when they come, they can, they're the ones who are not here, so.
اللي بحاول اعمله النهارده هو اني بعيد التفكير مره تانية في الوثائق دي معاكم. انا بحاول افكر فيها بصوت عالي شويه عشان انا محتاج كمان مساعدتكم فيها، علشان خاطر حتى لما عرضتها على بعض الزملاء والمتخصصين قوي سنوات طويله بنقرا وثائق العصر العثماني ما كانتش مفهومه، وقالوا تعبير شويه اتكد نسخ، انت بتبص في ايه؟ فيبدو ان المساله اعمق بكتير قوي من مساله كد النساء. فارجوكم ساعدوني في الوثائق اللي هنحاول نقراها سوا. بعد ظهيرة يوم السبت ذهبت الست غزالة بنت الرئيس محمد الصياد إلى المحكمة شاكية زوجها محمد الفران بأنه ضربها ضربا مبرحا ليلة أمس الأول عندما عاد إلى بيته ليلا بعد أن نامت، فلم تسمعه يطرق الباب وأنه دائما يشاددها، وتسأل القاضي إجرى الشرع الشريف. فأرسل القاضي من أحضره وسأله عما تدعيه زوجته، فأقر لزوجته أمام مولانا القاضي أنه لن يعترض على زيارتها لأمها ولا زيارة أمها له، وخرج على ذلك. دي واحدة من الوثائق. طب هو إيه معنى الوثيقة دي؟ زي ما حكى لي بعض الزملاء لما قرأناها سوا، هذه الحالات وغيرها الكثير توصف غالبا واستسهالا بأنها كيد نساء، وربما بأنها المرأة التي غلبت الشيطان، لكن الأخطر والأهم إنه بنحاول نوصل بالإضافات إلى إنها محاولة تأصيل ديني لمسألة إن كيدهن عظيم. أي من هذه التوصيفات لن يساعدنا في فهم هذه الحالة ومسيرتها، وهي كثير. لن يساعدنا في فهم لماذا وصل المجتمع رجاله ونساءه لما أسميناه كيدا. كيف نفهم سبب كيد كل منهما للآخر؟ ما الذي دفع بأحدهما ليخطط ويدبر ليكيد لشريك حياته؟ فهي لا تطلب الطلاق ليذهب كل منهما إلى حال سبيله، بل ستكمل الحياة معه. السؤال الأهم: ما هو موقف المرجعية القانونية أو الفقهية من هذا الذي أسميناه كيدا؟ إن كان الأمر ضررا بها فلماذا لم يعذره القاضي؟ وإن كانت كاذبة فلماذا لم يعاقبها؟ لماذا لم يطلب القاضي أو الزوج الكشف على الزوجة لإثبات أثر الضرب المبرح؟ لماذا لم يطلب أي منهما شهودا للواقعة؟ لماذا خرجا معا على حد وصف كاتب المحكمة بمجرد التزامه أمام القاضي والحضور وكتابة التزامه؟ لماذا نسيت ذلك الضرب المبرح؟ يبدو أننا بصدد نوع مختلف من الألم، هو مختلف عن العنف الجسدي أو الضرب. يبدو أن السبب الحقيقي هو المشاددة أو المضاجرة، راجل مقارتي يعني، أو الضرر النفسي الذي لحق بها لمنعها من زيارة أمها والاعتراض على زيارة أمها لها. لكن إن كان هذا الاستنتاج صحيحا فلماذا لم تشتكي مباشرة بالضرر النفسي؟ اشتكت، فهل سيوفر لها المرجعية القانونية والفقهية حلا أو إنصافا لها ودرءا لهذا الغبن النفسي الذي تعيشه؟ سأحاول فهم قضية العنف النفسي ضد المرأة في مصر في الفترة العثمانية، وعلى الأقل في الجلسة دي أنا هحاول أركز على حالتين. نقطة التماس فيهم بين الرجل والمرأة هو الطفل. الطفل هذا رضيعا كان أو قاصرا، ولأني بشوف إن الحالة دي بتجسد مقدار العنف والألم النفسي مش بس على المرأة لكن كمان على الطفل الصغير. عشان كده أنا بشوفها إنها ممكن تكون حالات دالة شوية إن احنا نفهم العنف النفسي، بس كمان لأني الأوراق المتوفرة عندنا وبتتكلم بنفس الطريقة، المقدمات شيء والخاتمة شيء آخر، كتير قوي. خلونا شوية نستعرض إيه اللي بيحصل جوه المحكمة. وأنا في الجزء ده أنا مش هحاول أفلسف الموضوع، هحاول إن أنا بس أستعرض معاكم إيه هي الحالة النموذجية، إيه هي الحالة الماستر اللي فوقها بيقولوا عليها، وإيه التنويعات اللي ممكن نشوفها جوه المحكمة اللي بتتضاد مع ده. فلا خلاف بين الفقهاء على أن إرضاع الصغير وحضانته هو حق من حقوق النساء أما كانت أو غيرها، وعلى الأب أن ينفق على الصغير ومن ترضعه أو حاضنته. وقد عني الفقهاء بوضع منظومة من الأحكام في مجملها تسعى لرعاية حقوق كافة الأطراف من جانب، وقيام كل طرف بواجبه تجاه الصغير من جانب آخر. وفصل الفقهاء بين أحكام الرضاعة والحضانة، لكن الأهم أنهم صاغوا ذلك الأمر بصيغة تعاقدية بين طرفي المسؤولية. ولا خلاف بين المذاهب الفقهية على وجوب إرضاع الطفل ما دام في حاجة إليه، كما أن الحضانة نوع من أنواع الولايات الثابتة بالشرع، والنساء مقدمات على الرجال في حق الحضانة باتفاق المذاهب. لكن هي أيضا ليست حقا للأم لكنها حق أيضا للمحظون للطفل، بمعنى أنه لو لم يقبل الصغير أو المحظون غير أمه أو لم يوجد غيرها أو لم يكن للأب ولا للصغير مال، يدفع لمن تستأجر أجبرة الأم على حضانة ابنها. ويقول الحنفية لو اختلعت الزوجة نفسها على أن تترك ولدها عند الزوج صح الخلع وبطل الشرط حتى لا يدار الصغير. على كل ذلك يكون أحق نساء رعاية الطفل هي الأم. ووضع الفقهاء سلسلة طويلة جدا من الأولويات، يعني لا داعي لذكر الأم ثم أم الأم وإن علت ثم أم الأب وإن علت ثم، لكن هذه السلسلة الطويلة خاصة بالنساء فقط كما هذه المرجعية الفقهية التي تحكم العلاقة فيما يخص الرضاعة والحضانة اعتبرت هي السند الحقيقي لأحكام القضاء في مصر طوال الفترة العثمانية. ودعونا نتحرك ونستنتج ونسمع حالات النساء داخل المحكمة. فبعد أن طلبت الحرمة سرية بنت هويدي من زوجها مخالعتها، ما قرر هو بنفسه لولده أبو بكر الرضيع التي رزق من مطلقته المذكورة في كل شهر 10 أنصاف خلا كسوتها ولوازمها الشرعية، وهو نفس ما فعله سليمان بن منصور الضبع مع مطلقته الحرمة برية. قرر على نفسه برضاه لابنته فاطمة الرضيع في كل شهر 5 أنصاف. لكن ماذا لو لم يتفقا؟ ماذا لو لم يقرر الزوج بنفسه حق الطفل أو ما تستحقه الأم كأجر لإرضاع الطفل وحضانته؟ في هذه الحالة يكون على القاضي أن يفرض عليه فرضا، وإن لم يدفعه تؤمر الأم بأن تستدين بهذا المبلغ ويجبر الأب على دفعه لاحقا، وهو ما حدث في حالات كبيرة. لكن يعني ما ذكرناه هو الحالة النموذجية أو الحالة المثالية. لكن على الطرف الآخر، لأن طبائع البشر لا تسير وفق وتيرة واحدة ولا تخضع دائما للنص النموذج أو الحالة المثالية، خاصة أنها حالة تربط بين زوجين منفصلين وما زال بينهما رابط وهو الطفل، ربما يسقي وتيرة الخلاف بينهما التي أدت إلى انفصالهما. قد تعددت وتنوعت الحالات، لكن أبرزها أذكر عددا من هذه الحالات. فمثلا حصلت 126 حالة قضية يطلب فيها الأب تسلم ابنه من مطلقته أو أم الصغير وإسقاط حضانتها، وسنده الشرعي أنه له متبرعة بالنفقة، نفقة الإرضاع ونفقة الحضانة. أكثر من نصف هذه الحالات كانت المتبرعة أجنبية عن الصغير لا تعرفه. 30% كانت أم الأب، الأمر الذي يقهر الأم دون أن تستطيع الدفاع عن نفسها إذا أجبرها القاضي على ترك الطفل أو هذا ما تحاول الدفاع به عن نفسها. لكن في حالة أخرى غير وجود متبرعة، وجدنا أن السيد دسوقي بن عطية الأعرج قد طلب من قاضي محكمة دمياط الشرعية أن يتسلم ابنه محمد الرضيع من مطلقة السيدة سليمة بنت عامر دراج لسقوط حضانتها، ومبرره لذلك أنها مقيمة بناحية قبيلة التابعة لمدينة دمياط وهو يقيم في المدينة، فأجبرها القاضي أن تسلم ابنها ما دامت تقيم في مدينة غير مدينة الأب. هذه الحالة هي حالة مهمة جدا تشرح مقدار التعسف اللي مارسه. لكن اللي بيزود الحالة دي وضوح اني وجدت قبل الواقعة دي اني الأم ذهبت عن طريق أمها كوكيلة لها إلى القاضي وطلبت من دسوقي أنها تستحق في ذمته أجر إرضاع ابنها منه مدة 6 أشهر مبلغا وقدره 6 قروش عددية، فأجابها بالاعتراف بالأجر وأنه دفعها للمدعية الوكيلة المذكورة فلم تقر رفضت، وعجز هو عن إيجاد بينة وطلب يمينها فحلفت، فألزم بدفع ذلك لها. الأمر الذي يثير شكوكا عندما طالبته بدفع الأجر والإرضاع، اعترف بقيمة المقرر ولم ينكره، ووقتها كان يعلم مكان إقامة زوجته وابنه الرضيع، ولأنه أجبر على دفع قيمة الأجر والإرضاع، أجر الإرضاع، فإنه جاء اليوم ليحاول القصاص منها، جاء اليوم ليحاول إسقاط حضانتها، ومبرره الشرعي أنها تقيم في مكان بعيد عن مدينة دمياط التي يقطن بها. طيب لماذا أقدم على ذلك؟ لماذا حاول الإضرار بها؟ هل هي النكاية بها؟ هل هو محاولة الإضرار بها؟ للأسف لدينا حالات متنوعة كثيرة استخدمت للإضرار النفسي بالأم، لكن فقط أذكر حالتين أو حالة واحدة. فمثلا خديجة بنت الرئيس محمد هي سيدة الإسكندرية، كاد عقدها الثالث أن ينقضي، مطلقة منذ أكثر من 5 سنوات من السيد علي السوسي، حيث كان مستوطنا بالإسكندرية، قبل أن يعود لبلده سوسة تاركا ابنه منها وهو طفل سعيد دون نفقة أو وصية، فأنفقت عليه من مالها الخاص. والآن عاد الأب لينتزع الطفل ذو السنوات ال6 من أمه، خاصة بعد أن علم أن مالا قد آل للطفل من أخته لأمه التي ماتت منذ بضعة أشهر. فعندما كان الطفل ابن عدة أشهر لم يكمل عامه الأول ويحتاج إلى من ينفق عليه وعلى مرضعته وحاضنته كما يوجب النص الشرعي، تركه لأمه، وبعد أكثر من 5 سنوات عاد ليقهرها، فانتزع بانتزاع الطفل منها، ويقهر الطفل أيضا بإبعاده عن أمه التي ألفها ولم يعتد غيرها. الأمر إذن ينطوي على قهر مركب، فهو قهر للأم في وضعها بين خيارين: إما أن ينتزع منها رضيعها أو رضيعتها، وفي هذه الحالة بنتها أو ابنها القاصر، وإما أن تفقد مصدر دخلها من عملها في إرضاع وحضانة ابنها وابنتها. القهر الآخر هو قهر للصغير مرضعا كان أو قاصرا، فقد الذي اعتاد على أمه ولم يعتد غيرها. السؤال هو: كيف للنساء أن يدفعن هذا الضرر النفسي عن أنفسهن وعن أطفالهن؟ هل وفر لهن المشرع سبلا لرد هذا الغب ودرء هذا القهر؟ ماذا يفعل المجتمع عندما لا يمثل القانون ما يراه الناس عدلا؟ هل استطاعت النساء أن يجدن طريقة أو حيلة للاحتفاظ بأولادهن الرضع؟ النتيجة الأولية التي يؤشر إليها إحصاء حالات احتيال، يكون هذا اللفظ دقيق لكن الفقهاء ذكروه بعد ذلك في توصيف الحالة، الاحتيال بوجود متبرعة، أنه من بين 126 قضية ادعى الأب أو من يلزمه نفقة الصغير وجود متبرعة، قابلت 117 أم، ما يمكن تسميته خيار أهون الضررين. يبدو أن ألم انتزاع صغيرها أشد وأقوى من ألم تنازلها عن حقوقها المالية في الأجر، أجر الرضاع وأجر الحضانة ونفقة أولادها رضيعا كان أو قاصرا. تدفع عن نفسها ألم القهر من انتزاع الصغير منها، وتدفع عن صغيرها أيضا القهر من حرمانه من أمه. والحالات الأخرى رفضت المجيء أمام القاضي، 9 حالات رفضت المجيء أمام القاضي وعليه وصلت لنفس النتيجة، حيث أسقط عنها القاضي الحق في مطالبة بالنفقة أو أجر لحضانة الصغير. ليس هذا عن غنى منها أو عدم احتياج للنفقة، بل إن بعض هذه الحالات كن مضطرات أن يشترطن على أزواجهن الجدد أن يتبرعوا بالإنفاق على ابنها، مما يدل على فقرها وشدة احتياجها، وكتبت ذلك ضمن وثيقة الزواج حتى تضمن وفاءه. هكذا يبدو أن كيد الرجال غلب كيد النساء، ليس لأنها قليلة الحيلة، لكن يبدو أن التزام القضاء بتنفيذ حرفية النصوص القضائية، أو على حد تعبير يحيى حقي في روايته يومياتنا في الأرياف، ليس مهما الوصول إلى العدالة، فالأهم هو تطبيق القانون. هو ما أثار بعض الفقهاء هذا الزمان، فعمد بعضهم إلى كتابة بعض المؤلفات الفقهية التي تناقش هذه القضية. منهم على سبيل المثال عندنا هذكر اثنين، الشرنبلالي، حسن الشرنبلالي، وده كان في بداية العصر العثماني، نهاية في القرن ال16. الثاني كان في القرن ال18 هو ابن عابدين. فللأول مخطوطة تسمى أو اسمها كشف القناع الرفيع عن مسألة التبرع بما يستحق الرضيع، والثاني له عمل آخر بعنوان الإبانة في أخذ الأجرة على الحضانة. كلا العملين يشير تكرار نسقهما إلى مقدار تداولهما وربما الاحتياج إلى ما جاء فيهما، فقد حاول التنبيه إلى مقدار القهر الواقع على النساء، وكلاهما يبني اجتهاده الفقهي على سؤال يعبر عن واقع الحال. فيقول حسن الشرنبلالي بأنه سئل عن رجل طلق زوجته وفرض لرضيع له عليه قدرا يسيرا أحقر من أن يذكر لأمه في نظير إرضاعها وحضانتها والقيام به والسهر، ثم أراد قطع ذلك المقرر بدعواه وجود متبرعة، فهل يؤخذ الصغير من أمه وتقهر ويدفع به لمن زعمت التبرع؟ سواء كان ذلك السؤال طرحا من أم معنفة أو من ذويها، أو طرحا من المؤلف باعتباره ضميرا لمجتمعه، فإنه يعبر عن وجود شعور ما بالقهر والغبن أو الضرر النفسي إضافة للضرر المادي. وقد تميز مؤلفين بأمور ليست شائعة بين فقهاء زمانهم، حيث أنهما في عملهما الفقهي لا يعتمدان فقط على رواية الأسبقين واجتهادات أساتذتهم وشيوخهم من علماء المذهب الحنفي الشريف، ولكن على واقع الحال المعاش وما يشاهدان حولهما من تغير الأحوال وطبائع العباد. فهو ذا أهمية في استنباط حلول فقهية. فنجد مثلا الشرنبلالي يقول: نحن نشاهد حالنا مع أم ولدنا الذي معها غيره، وكذلك نرى ونسمع جيراننا وأولادهم، لولا أن الوالد يحث الأم على القيام لأخذ الولد في كل ليلة مع بكى الصغير وشدة تعبها لتقوم وتسكت الولد بإرضاعه وحمله وإزالة بوله، ثم يعود ليستشهد بحال المرضعات المستأجرات لمرض الأم أن الوالد يعطي المرضعة أجرا وفيرا ويطعمها ما أحبت ويطعم من معها من أولادها وزوجها، ثم إنها تظهر العجز وتغيب عن إرضاع الصغير بما يؤدي إلى ضرر، مع أنه مع أبيه ومع أمه. يستخدم مشاهداته ذلك في استهجانه أفعال الفقهاء والقضاة. إكراه الأم بمجرد قول الأب أن عنده مرضعة متبرعة، فيقدم على تكليف الأم بدفع الولد أو أخذه وإمساكه بغير أجر، بل يصل به الأمر إلى حد تعنيف والطعن في استقامة هؤلاء القضاة، فيقول: ولا يفعل ذلك إلا من علم عدم استقامته وحاله، حسبنا الله ونعم الوكيل. ويحث القضاة على ضرورة أخذ الحيطة والحذر والنظر في حال هذا الأب المدعي، هل هو فعلا معسر لا يستطيع دفع نفقات الصغير؟ فإن ثبت عدم إعصاره لا يستجاب له مع وجود المتبرع، بل وإن ثبت إعصاره فعليه أن يعمل ويجد، ولو وصل به الأمر إلى حد التسول لينفق على ابنه، وإن لم يفعل مع قدرته على العمل سجن. وأمرت الزوجة أن تستدين على ذمة زوجها حتى إذا كان الزوج أن تستدين على زوجها فيرد ذلك أو فيسدد هذا الدين بعد خروجه من السجن، ولا يجرؤ على إيذاء مطلقته ورضيعها. ثم نجده، هذه لأول مرة يعني أشاهدها في مثل هذه الحالات، ثم يضع للقاضي آلية للتحوط من المتبرعة فينظر لحالها، هل هي أجنبية؟ هل هذه الأجنبية المتبرعة لديها لبن؟ هل معها رضيع يزاحم الذي تريد التبرع بإرضاعه وحضانته؟ هل المتبرعة قوة وقدرة على القيام بالولدين؟ ثم يحث القاضي على سؤال جيرانها الثقات، هل ظاهر حالها القدرة على السهر وإرضاع والصبر على إزالة الخارج من الصغير والأجنبي، وتصبر على السهر به الليالي الطوال خصوصا مع شدة البرد، وتترك الكن والغطا والدخول مع زوجها في الفراش لتقوم برعاية الصغير عند بكائه، ثم ينظر مرة أخرى إلى حال زوج المتبرع. هل هذا زوج؟ هل يرضى بمزاحمة ابنه في الرضاعة والسهر به والقيام به؟ هل يرضى زوجها ظاهرا وباطنا بأن يصدق ظاهره بكونه غنيا سامح النفس رقي الأخلاق واسع النفقة تاركا نظره لما يطلبه الزوج من امرأته فيتركها لتقوم بإرضاع الولدين؟ حاول الفقيهين حسن الشرنبلالي وابن عابدين أن يضع العراقيل أمام هذه المتبرعة وأمام هذا الأب الذي يكره الأم على ترك جنينها، على ترك رضيعها أو قاصرها لمجرد وجود متبرعة. لكن مع شديد الأسف مع وجود هذين المؤلفين وكثرة نسخهما وتكرار وجود نسخ حول العالم من هذه النسخ، إلا أننا وجدنا أن حالات حاولت قهر الأم ونزع الصغير منها نظرا لوجود متبرعة هو أمر متكرر ومستمر في المحاكم. يبدو أن هذا ما جعل بعض النساء يلجأن إلى حيلة أخرى. فالسيدة خديجة التي تحدثنا عنها منذ قليل وزوجها علي السوسي هي بادرت من نفسها وذهبت يوم الأربعاء الخامس من شهر المحرم سنة 1187 الموافق 16 فبراير 1774 بالذهاب إلى مولانا القاضي الشرعي ومطالبته بإجراء الشرع الشريف وتحقيق العدالة ومراعاة مصلحة الطفل الذي اعتاد على أمه دون أبوه الذي هجره لأكثر من 5 سنوات دون نفقة أو وصي يباشر مصلحته، وأيضا لخطورة الطريق بين مدينة الإسكندرية ومدينة سوسة. لكن الملاحظات يمكن أن نتوقف عندها في هذه القضية، حيث أن الطفل حسب إقرار الأم هو في 6 من عمره، بالتالي لم يصل إلى السن الذي يمكن مطالبة الأب به وهو 7 سنوات. إضافة إلى أن الأسباب المدعاة من الأم يمكن معالجتها بشكل أو بآخر بحيث يضمن الأب الحكم لصالحه، فهو يستطيع أن ينتظر عاما آخر حتى يبلغ الطفل 7 أو حتى الالتزام بعدم السفر من الإسكندرية، وأن يدفع لها ما يقرره القاضي عن نفقة وأجر وإرضاع الحضانة، ووقتها سيمكنه القاضي من أخذ الطفل. الملاحظة الأساسية والأكثر أهمية أننا لم نسمع أو لم نرى الأب بين الحضور في المحكمة، ولم يسجل كاتب المحكمة أن القاضي استدعاه، الأمر الذي يدفعنا إلى إعادة التفكير في القضية من جديد. يبدو أن السيدة خديجة قد ذهبت لمولانا القاضي بعد أن أنفقت الكثير من الوقت في التفكير في قضيته، وربما استشارت آخرين من الفقهاء في أضمن السبل لكسب قضيتها، حيث أرادت السير بالقضية إلى أبعد من مجرد منع الأب من أخذ الطفل منه أو منازعتها في حق ضم ابنه له. أهم من منعه من استلام الثروة الموروثة آجلا أو عاجلا، أرادت أن تستلب منه أمرا آخر، تعيين وصي على ابنه يحسن إدارة ثروته، فيؤول هذا الحق في التعيين لولاية القاضي العامة، فلجأت إلى مستوى ثاني وهو التشكيك في قدرة الأب على إدارة ثروة الطفل وتنميتها واستثمارها، وعليه فالأب غير مأمون على الطفل وغير مأمون على ثروته. وحتى تتثبت من ضمان الحكم لصالحها، فقد أتت معها بنصي فتوى من المفتي المالكي والحنفي بالصغر الاسكندري اللذين أيدا أحقيتها في منع الأب من أخذ الطفل منها حتى لو بلغ السن القانونية، وبعدم أحقيته في استلام ثروة الصغير. على كل الأحوال فالسيدة خديجة لم تكن الوحيدة التي استطاعت تكييف قضيتها بالطريقة التي تضمن لها دفع هذا الضرر النفسي وتضمن بقاء الصغير معها دون منازعة الأب، سواء بكيد النساء أو مثل الدارج في مصر خليك مع الزور لما توصل الحق، وربما باستراتيجية الهجوم خير وسائل الدفاع. ختاما، أصبح القانون لا يضمن تحقيق العدالة بين أفراد المجتمع، عندما يصبح حرص الدولة ممثلة في السلطة القضائية على تطبيق القانون أقوى من حرصها إلى الوصول أو إلى تحقيق العدالة، وقتها قد يصبح القانون هو الضامن لاستمرار عنف الرجال ضد النساء، فإن المجتمع مضطر إلى خلق الآليات التي تمكنه من تحقيق مصالحه، ولو كان بالالتفاف حول القانون أو ما أسميناه في البداية استسهالا كيد النساء. هذا الكيد لم يكن إلا مجرد أحد هذه الآليات للدفاع عن أنفسهن وتحقيق ما يرونه عدلا، وتمكينهن من الدفاع عن أنفسهن ورفع الضرر النفسي، حتى ولو كان عملا بمبدأ خليك مع الزور لما توصل الحق. يبدو أن السؤال الذي بدأنا به كان خاطئا أو غير دقيق على الأقل، إذ أن مفهوم العدالة ليس مفهوما مطلقا، فهو مفهوم مصنوع أو مفهوم منتج، هو مفهوم متغير ويحدده القادر على تكييف الحالة وفقا للمقتضيات القانونية، وعليه فإن تحقيق العدالة هو أمر غير منوط بالقضاء فقط، فالمجتمع شريك في تحديد مفهوم العدالة وآلية تحقيقها أو رفع الظلم بأشكاله ومنها العنف النفسي. يبدو أن هناك نوعا من الاتفاق أو حتى القبول المجتمعي لذلك، فالزوج يعرف أصل العلة ولم يطالب زوجته بإثبات الضرر الواقع عليها وضربها، والقاضي أيضا كان يعلم أن زوج السيدة خديجة لم يحضر ولم يطالب بابنه منها، ومع ذلك لم يطلب حضور حتى يسأله عما هو منسوب إليه. تبقى الأسئلة مفتوحة. إذا كان القانون وحده لا يضمن تحقيق العدالة ورفع الظلم عن النساء في مثل هذه الحالات، كيف نضمن عدم الوصول إلى هذا العنف النفسي ضد النساء والذي يبدو أنه متزايدا حتى الآن وباضطراد؟ كيف نخلق ثقافة مجتمعية تعمل على تحقيق العدل؟ كيف نساعد الأم أن تربي ابنها وبنتها على ألا يعنف زوجته أو أطفاله؟
أولاً أهنئك. I'm congratulating Ramadan because I'm familiar with the material he uses. He promised me this work on talaq and it's not happening, so I'm happy that something's coming. And basically بهنئك لسبب بسيط جدا. I'm congratulating you for a very simple reason, and that is you actually showed something in these sources that most of us have not seen. طلعت حاجة من الوثائق دي أغلبيتنا اللي بيشتغلوا فيها ما شافوهاش، وأهنئك تهنئة كبيرة. لازم يكون حد بيشتغل بيهم بقوة زي ما أنا بعمل عشان نفهم أنت وصلت لإيه. بصراحة مش عارفة وصلت لها إزاي، بس وصلت لها. هو إن أنت دخلت وريت المشكلة اللي أكبر في استعمال المحاكم الشرعية، وإن إحنا تملي بنبص على اللي مكتوب ما بنبصش على اللي غير مرئي. أنت هنا حاولت تطلع من التكست لما وراء التكست. وهنا أحب أن أنا يعني أتكلم عن اللي قالته الدكتورة أسماء بدري شوية عن المشكلة بين القانون وبين التطبيق بتاعه وبين العادات and so on, because اللي أنت قلته هنا بيجي ماشي مع اللي قالته بالظبط، بس أنت بتتكلم عن المحاكم الشرعية وبتتكلم عن النهارده. اللي أنت عندك هنا إن مفيش، المهم إن أنت تطبق القانون بأي طريقة. القانون ده مكتوب بطريقة لأسباب معينة، فبتطبق القانون حرفياً، وبالتالي موضوع إن يكون في justice أو مفيش justice أو إن أنت تدي قضاء بيحاول يدي الحقوق، ده مش موجود. المهم إن أنت تطبق القانون. القانون مكتوب بطريقة عن طريق وثيق كاتبينها مكتوبة بطريقة يعني أبوية، وبالتالي عمرها حتى لو الكلام مفروض يكون في مصالح المرأة عمره ما هيكون في صالح المرأة، لأن هو من الأصل القانون والمرئي أو غير المرئي مربوط بمفهوم من الأصل بيبص للمرأة زي ما أنت بتقول بطريقة كيد او بيبص لها بطريقه ان هي ند، مش بطريقه اللي هي لمعالجه او لها حقوق او يكون في نوع من الجاستس. فان انت تدخل في حكايه الرضاعه وازاي في الرضاعه انك القانون وترجع للشريعه والستر محطوطه بطريقه ان بتدي للست حقها في الرضاعه، ودي حاجه تملي يقولها لك ده حق للست ودي حاجه في مصلحتها. لكن اللي انت وريته النهارده انك بتيجي ضدها طول الوقت، لان بتيجي ضدها لانك انت ممكن انك تجيب حد محلها وتمنعها من ان هي تاخد الرضاعه بتاعت ابنها، ودي من الناحيه النفسانيه مفيش حاجه اكتر من كده، ان انت تشيل العيل من امه بدون اي اكتراث، واخد بالك؟ وارجع اقول طيب الست لما بتتجوز ما بتاخد بنتها منها، تاخد بنتها وتديها لجدتها ليه؟ عشان اتجوزت راجل غريب. تفرق ايه؟ لو ما يكون الاب مش عاوز بيدوها للست مع الراجل الغريب. دي الحاجه اللي انا عمري ما فهمتها. يعني بتلاقي حاله اللي فيها يمنع عشان في راجل غريب في البيت، وحاله تانية لا ولا فارقه مع الراجل. ليه؟ لان الاب ما فرقتش معاه، ما طالبش. فالقاضي نفسه مش باصص لها من ناحيه اللي هم بيقولوا الحجه الشرعيه ان في راجل غريب في البيت، لا ده هو عشان حق الاب هو اللي ما جريش ورا الحق. فالموضوع مش موضوع يعني موضوع يعني زي ما تقول مفهوم للشرع او مفهوم لمصلحه البنت او مصلحه الست زي ما هم بيتكلموا ويقولوا، لا ده هي فعلا لها بياخدوا القانون بطريقه ان هم بيتحايلوا. دي نوع من الحيل اللي بيها القانون بيبقى ان هو ماشي مع يعني مقاصد الشريعه، لكن اللي هو الرحمه وكده، بس هو بالحقيقه فهو تنفيذه بيبقى بالطريقه الابويه. Did you all understand what I'm talking about? The other level of the discussion يمكن انت مش واخد بالك منه، انت بتتكلم على القاضي جاستس. القاضي جاستس اللي هو حاجه الكتاب الامريكان كتير قوي لما في الغرب لما ابتدوا يتكلموا عن القضاء العثماني او القضاء ما قبل الحداثه، بيتكلموا تملي عليه على انه دوت قاضي جاستس. يقول لك على ان ده قاضي تحت الشجره وبيقول اللي هو عاوزه، بيخرف زي ما عاوزه، بياخد يعني معنى كده ان مفيش زي ما تقول نظام موجود للقضاء. طبعا احنا اللي كتبوا على الموضوع ده وروا ان ده مش كلام مش حقيقي، بس اللي انت بتقول دلوقتي ان قاضي جاستس السيستم دي كانت احسن من السيستم اللي بعد كده، لان في قاضي جاستس ان القاضي بيقعد مش مهم الشرع بيقول له ايه، وكتير بيقول لك على راي من قال، على راي من يرى ذلك. يعني كتير قوي حالات بتخلص كده، لكن معنى كده ان هو بيبص على الحق، بيبص على ايه الصح وبينفذه. يمكن ده التناقض اللي بين حاله وحاله من اللي انت بتقراها، ان في حاله القاضي بيلاقي لها وفي حاله القاضي ما بيلاقي لهاش، وهو بالفعل هم بيقدر مش حسب المدرسه اللي هو فيها او حسب نوع القضاء اللي هو بيكلمه، لا ده حسب هو شايف ايه. وطبعا وده بيورينا الفرق الكبير قوي اللي اتكلمنا عليه قبل كده اللي بين القضاء بعد الحداثه وقبل الحداثه. ان هو بعد الحداثه بيقول لك ان القانون يونيفورم يونيفرسال، فبيسموه بوزيتيف لو يعني ان هو ما بيفرقش بين شخص واخر. ده المفروض، واخد بالك؟ ودي طبعا اللي هو الخطاب اللي مش حقيقي، انت فاهم ازاي؟ اللي مش حقيقي، بس هو ده المفروض الفرق بين نوع من القانون والقانون. فاللي انت بتوريه يمكن تحب انك تكتب على المواضيع دي كلها في البحث ان شاء الله تخلصها كورقه للنشر، يعني ان فعلا الموضوع ده يعني محتاج ان هو يتعاد النظر فيه. ان الموضوع القاضي جاستس، مش عارفه الكلمه بيقولوها بالعربي ايه، لان نعم لها مصطلح. هي قاضي جاستس دي اللي هم كتبوا عنها كتير قوي، اقدر اديك مراجع كتير بتتكلم عن ده. ان دي يعني ده موضوع ممكن فتحه تاني، لان الناس ما فهمتوش كويس ان القاضي كان فعلا بيمشي على اصول قبل كده، وكان فعلا عنده مدرسه بيمشي عليها، بس في نهايه المطاف هم كانوا احسن بشويه، لان هو مش مضطر يحط القانون. النهارده لازم يحط القانون، النهارده لازم يحط القانون. زمان قبل كده قبل الحداثه كان كتير قوي ما يحطش القانون، عشان كده بيطلع منه وبيلاقي له مخرج. يقول لك على مذهب من يرى ذلك، لان عنده 4 مدارس ممكن كان يلعب فيها، ممكن ياخد ابن عابدين وياخد غيره وغيره وغيره. النهارده ما تقدرش، القانون بيقول لك كذا فهتبقى كذا، ولو انه برضك بيتلعب، انت فاهم ازاي؟ بس مش بالطريقه دي. هو ده اللي هو رمضان. I hope you understood اللي هو اتكلم عنه، بس هو ده
بيكلمونا عن تحقيق القانون، بس القانون ده كمان مش حاجه واحده. القانون ده له ان عندنا 4 مذاهب والاربعه متاحين مع بعض، واحتمال في نفس المحكمه او في نفس القاعه، وبالتالي هي عندها القدره وعندها القوه انها تروح تحدد انا مصلحتي مع مين. هي عندها القدره انها تصيغ الاشكاليه بتاعت المشكله بتاعتها او القضيه بتاعتها
اختار القاضي اللي تقف
بالطريقه
قدامه.
اللي تحقق مصالحها. طبعا ممكن نقول انها استعانت بحد، سالت حد، سالت كاتب المحكمه، سالت غيره، لكن في الاخر هي عندها القدره انها تختار ازاي تقدر تحقق مصالحها. في الدوله الحديثه ده ما عادش ممكن. هي عندها اختيار واحد بس، هي عندها انها هتروح والاخر يحدد لها ايه هو مفهوم العداله. كمان مش صيغه واحده. العداله هو ما هو سهل قوي انا اقول طب ما هو من حقي ان انا اخد ابني وفقا للقانون، فهي دي العداله. بس هي شايفه ان اخذ الابن ده نوع من القهر ليها، مش عداله. مين هيحدد ايه هي عداله ومش هي مش عداله؟ هو ما فيش صيغه نازله في السماء اسمها العداله. احنا كمجتمع اللي بنقرر ايه هو العداله، وبالتالي ازاي اسلك طريق، ازاي اتبع منهجيه، ازاي اكيف القضيه بتاعتي علشان احقق اللي انا شايفه عداله. انا كمان فاعل في استخدام في تنشيط العداله دي، مش بس القضاء ومش بس القانون، المجتمع كمان فاعل جواه.
حاجه مخيفه ان القانون مش بيقف مع الست. كان موجود مش بس في العصر اليومين دول، ده موجود من الاول، انه صيغه القانون او حتى قانون موجود بعد ما بيجي يطبق في المحكمه بتلاقي له طريقه كده ان هو بيروح بردك. من ناحيه سيكولوجيه حكايه النساء دي بردك محتاجه الواحد يرجع لها. حاجه تانية كنت عاوزه اقولها لو ممكن. انا كنت وانت بتتكلم على الحاله بتاعه الحما بتاعه العيله، افتكرت احنا ما بنتكلمش تملي عن المشاكل بتاع العائلات دي، بس هي المحاكم دي كلها مشاكل مع عائلات، فيمكن حد يحب يكتب على دي في يوم من الايام. Talking about the case that you talked about, the fights between the family. There's so much records about, family squab, but we don't really take it to that local. That a lot of the laws that came out are really about family disputes, very local family disputes. That later on you find a lot of decisions that become established in law. We don't really take that into consideration at all, but a lot of those cases are just about families that don't like each other. I'm reminded of a case that Dr. Nelly Hanna once told us and made us all die of laughter, and basically it was a marriage contract in which the wife told her husband that on Fridays my mother and my brother will be visiting, and you are not to be in the house when they visit. I've never forgotten that case, but it tells you the whole story, about that, exactly what these family disputes are about, and how that husbands never got along with the wife's family. I don't know why, but it's our part of the world anyway. It's ماليش دعوة, it's different.
There are instances في حالات العادات المتأصلة والناس لسه طبعا الشغلات نفس الشغلات. في كيس في السودان كانت يمكن أسرع كيس بتاع الطلاق، أن الزوج متشاجر مع زوجته حيضربها، الأم دخلت بيناتهم عشان ما يضربوا بعض، راح ضرب الأم. فالزوجة طلبت الطلاق من المحكمة لأنه إذا أمها مسألة في العادات السودانية في ريفير الحما، الراجل لا يمكن يعمل حتى يتلفظ لفظ أمام حماته، وعادة متأصلة إلى الحد اللي حتى الآن موجودة، أن الرجل حتى إذا كان بيضحك وحماته دخلت هو بيسكت، ما بيقول أي حاجة. إذا حماته مثلا طلبت منه طلب وما أجابه راح في داهية، ده ما هو راجل. تركوا كل الشريعة وليه هل هي دينية مقبولة، وتحدثوا عن هذه العادة السودانية، وطلقت الزوجة على هذا الأساس.
يقولني الثابت بالعرف كالثابت بالنص ما لم يخالف نصا. الثابت بالعرف كالثابت بالنص ما لم
لا،
يصطدم مع
في
نص.
أشياء ثابتة بالعرف لكن
طبعاً.
يتجاهلوها لأنها ضد المرأة. هذه واحدة من العادات اللي ما قدروا يتجاهلوها، لأنه القاضي نفسه لا حول الله ضربت حماتك يعني المسألة غير مقبولة على الإطلاق. لكن في أشياء كثيرة تانية يتجاهلوها تماما، يقول لك لا هذا هو الشرع وهذا هو حق الرجل وهذا.
انا الحقيقه بس عندي تحفظ على مساله الشرع دي، انا بخاف قوي من استخدام كلمه الشرع، انا دايما بستخدم كلمه الفقه، لاني اول ما بنقول الشرع يعني وانا حاولت طول الورقه وانا بكتبها او المناقشات اللي عملتها جوه الورقه اني ما استخدمش كلمه الشرع، لاني اللي احنا بصدده هو اجتهادات فقهيه، وبالتالي راي ناس علماء على عيننا وعلى راسنا والشيوخ كبار، لكن اجتهادات يؤخذ منها ونقول له لا ده غلطان، هو اجتهد ولكنه اخطا. لكن اول ما بنقول كلمه الشرع شويه الكل بيبتدي يبقى
عشان تسكت الناس، بمجرد ما نقول الشرع معناها ربنا قال كده.
بالظبط فبنديها قدسيه.
جاء الوقت ان احنا نغير المفهوم ده. الشرع ما هو الا فقه بقى نص، وبالتالي قبل على انه هو كلمه شرع زي الفقه بس بقى نص مقبول. شرع النهارده غير طبعا القرآن موجود، يعني زي ما بنقول العمل لكن احنا اعتبرناه شرع ادينا له نوع من الهولينس اللي ملوش اصلا.
ان هو عايز يدي نفسه قدسيه، هو عايز يدي نفسه مكانه زي الاستاذه بتقول يعني، وبالتالي انت هتعارضني في ايه؟ ادرسك الاول. ده انا اللي بقول يعني انا الفقيه فلان.
I don't want this result. Please, you need one of these.
بالعربي. اوكي بس عندي سؤالين. اولا شكرا على التوك. سؤال اعتقد جزء من التوك تبعتك هو ركز على مساله حرمان المراه من حق الحضانه. مزبوط. حرمان الحق المراه من الحضانه كتجسيد لعدم تحقيق العداله، بس مرات في حالات وين المراه تعطى الحق بالحضانه وهذا تجسيد لعدم العداله، لانه المراه بتضلها تدفع كوست كثير عالي لانها عم تحتضن الاولاد، من ناحيه انه ممكن ما تتجوز، من ناحيه انه لازم أن تشتغل، لازم يعني بتحرر الزلمه من اعبائه لما هي بتاخذ الحضانه في بعض الاحيان، بنشوف هذا في مجتمعات مختلفه. هي اول جزء. ثاني جزء بتعلق وانا بتفق معك انه الفجوه ما بين القانون والعداله وتطبيقات القانون والعداله، بس احنا اللي عم نشوفه انه انت قلت انه المجتمع بفهم انه هاي الفجوه، انه بالنسبه له بشوف القانون وبشوف ان القانون لا يحقق العداله، بس بده يطبق القانون. مش بس المجتمع، حتى مثلا الحراك النسوي ضد العنف في مجتمعات مثل مجتمع الاردن، خلينا نحكي هذا المجتمع مركز كثير على القانون كالمنطقه وين احنا بنقدر نعمل تحريك او حراك ضد العنف. فلما الحراك النسوي نفسه يعلق اماله على القانون ويعلق انه efforts تبعونه للاندنج فايلنس على القانون، وين هاي الفجوه اللي انت عم تحكي عنها؟ انت بتقول انه المجتمع فاهم هاي الفجوه، بس انا برايي انه المجتمع لا يرى الفجوه ما بين القانون بالطريقه اللي انت بتتصورها.
انا بتصور ان المجتمع مش كله خبير قانوني اكيد. فاللي مهتمه الست دي مهتمه او الراجل ده مهتم بان يحقق اللي هو شايفه عداله، بغض النظر هو لجأ بيها للقانون او بالعرف او باي وسيله اخرى. حريص على تطبيق القانون لانه ده بيديله ثقه هي السلطه، قد تكون ممثله في السلطه القضائيه او غيرها، فالسلطه حريصه قوي تقول النص عندنا بيقول كده، بس المجتمع يقول لك حتى لو النص بيقول كده، حتى لو كانت مصالحه دي زي ما قلت في اللحظه الاولانيه مفهومها مختلف، ان ده مصلحتك بس ضد حد تاني، كل واحد فيهم عايز يحقق. فالمجتمع في رايي هو عايز العداله. لما الدوله عايزه تفرض نفوذها او هيمنتها على الناس، هي اللي بتلتزم بحرفيه القانون.
البلد يعني.
What I'm saying isn't the state. I'm saying حتى الحراك مثلا اللي هم الناس اللي المفروض انه فاهمين انه في فجوه ما بين القانون وتطبيقاته ومفهوم العداله، بيركضوا ورا القانون، فتغييراتهم حراكهم مثلا بيكونوا بيحسبوه بالقانون، فهم بيقولوا خلينا نغير القانون حتى يصير في عداله. بحكي لك مثال من امثال الاردن مثلا، اللي هو مثلا الحراك الاسود حسب نفسه في تغيير قانونين 340 98 بيتعلقوا بما يسمى بجرائم الشرع. ليش حصل حالهم؟ لانه قال لك إنه هذا القانون هو المشكله، كيف بتشجع الرجال على عمل هذه الجرائم، بدل ما يطلعوا على المجتمع نفسه كيف هو بيطلع على العنف، ركزوا على ناحيه القانون. فبرايي انه الاسامبشن انه المجتمع يفهم انه في فجوه ما بين القانون والعداله مش صحيحه 100%، لانه بتفترض انه الناس بيقسموا بين الاثنين، وانا برايي مش هاي القسمه.
انا موافق، لكن بس مختلف ان احنا نقول ايه المجتمع بالالف واللام وبالتالي بنتكلم على كل البشر، او بنقول الدوله وبالتالي بنتكلم على كل القضاة، بنتكلم على كل الفقهاء، بنتكلم على كل المذاهب. دي مساله لازم شويه نبقى عشان كده في الاخر انا قلت هل نقدر عند المجتمع تخليه هو نفسه قادر يتلمس ايه هو مفهوم العداله، قادر يتلمس هو القانون، لان القانون نقدر نغيره اذا كانت العداله المطلوبه. فالقانون مش هو المفتاح الاساسي اللي نقدر.
بس هضيف نقطة كمان يعني اللي اتفضلت فيه ده، أنا يعني مهم إنه كمان المجتمع مش هي منظمات المرأة. يعني منظمات المرأة أعتقد إن يعني كتير مدفوعة باليونيفرسال كونفنشنز عن حقوق المرأة، مش بالضرورة بينطلقوا من تغيير القانون من احتياج المجتمع للتغيير.
انه جهل مني انا يعني. هل التحول ده من القاضي بيحاول يركز اكتر على العداله للقاضي النص اكتر، جه معاه او جه في وقت كان فيه تحول من ناحيه ان الجهه اللي كانت بتنظم عمل القضاه دي مثلا اتغيرت، فبقى القضاه عندهم حريه اقل، هو بيلتزم بالنص مش بيلتزم بان هو يوصل للعداله عشان يامن وظيفته هو او يامن مصدر الدخل بتاعه هو.
احنا ما عندناش مؤشرات، على الاقل في العصر العثماني ما عندناش مؤشرات تقول لنا ان الدوله اتدخلت عشان تحد من سلطه القضاء او تحدد المسار اللي يمشي فيه. في السنوات الاولى من الاحتلال العثماني لمصر حاول المقنن العثماني انه يعمل ده، لكن كان في مجابهه قويه جدا، ومن خلال الفعل ورد الفعل وصلوا لصيغه ما، وهو ان الحنفي هو الراجل الكبير بس يجي زي الحاكم كده، زي الوالي يقعد في القصر، لكن باقي المذاهب موجود. فهو داخل محكمه مثلا في محكمه البرمشيه مثلا او اي محكمه في القاهره موجود الاربعه، هو الكبير بتاعهم، لكن هو ما عندوش سلطه فعليه او ملوش تمايز على الاخرين الا في بعض التخصصات، اهمها ما يتعلق بالفلوس. لو كانت عقد الصفقات الكبيره، لو كان امور خاصه بالدوله، لو كان امور خاصه بعسكريين وبالتالي هم في الغالب العسكريين هم عثمانيين، لكن ما دون ذلك من شؤون المجتمع كان عند الفرد كل الحريه ان يختار هو الوكيل هو يعمل ايه. وبالتالي انا مش متاكد قوي ان الدوله قدرت تغير المسارات اللي الناس بتسلكها عشان تحقق العداله.
لا انا هقول لك اكتر على القاضي نفسه، على شخص القاضي. يعني مثلا احنا عرفناه في الكورس حضرتك بتبقى ان
الخطاب الديني مثلا بتاع العلماء اختلف لما الاوقاف بقت تبع للدوله مش جهه مستقله.
صحيح.
فهل كان في حاجه زي كده مع القضاه ده اللي خلاهم يتبعوا النص اكتر من ان هم يتبعوا بالاعراف والحاجات دي كلها عشان يامن وظيفته هو او يامن مصدر الدخل بتاعه؟
الحقيقه لغايه نهايه العصر العثماني او لغايه بدايه القرن ال19 لا. بعد كده كان اصبح فيه يعني خارج الفتره الزمنيه على الاقل اللي اتكلمت عنها، كان في محاوله للدوله انها تفصل بين القضاه وتحدد كمان المدارس اللي يدخلوها، تحدد المسار اللي هم بيمشوا فيه عشان يتعلموا. لكن ده بدايه من القرن ال19 ما نجحوش على تنفيذ ده بشكل قطعي الا في النص الثاني من القرن. ال 19. يعني كان في محاوله طول الوقت ان السلطه بتحاول تدي نفسها الايدين العليا اللي تسيطر، لكن حركه المجتمع انا في رايي كان طوال ال3 قرون كانت اقوى، هي عايزه تحقق مصالحها اكتر. مع محاوله فرض الدوله المركزيه محمد علي وان هو يبقى في ايديه كل حاجه قدر ينجح الى حد ما، لكن بعد محمد علي بدايه من نص القرن ال 19 الدوله العثمانيه فرضت بشكل نهائي المذهب الحنفي، وبالتالي كل الخيارات الاخرى اللي كانت متاحه امام الناس اتعدمت. فكلامك مظبوط جدا بدايه من النص الثاني من القرن ال 19. قبل كده انا متشكك جدا ان يكون عندنا مسارات قصت وبالتالي اصبح في مسار محدد.
My presentation is on sexual harassment in Egypt as being a manifestation of class struggle, state oppression, and women's empowerment. So although sexual harassment is a worldwide phenomenon, Egypt only occupied a top position on the map of sexual harassment on a world scale in the recent couple of years. In 1997, the Population Council in Egypt, which is a branch of an international research organization, published a report named the Adolescence and Social Change in Egypt survey, naming the 6 top priority issues for youths in Egypt at the time. And the results identified tobacco use, malnutrition, and delayed growth, amongst other topics, as priority issues for youths at the time in Egypt, but the list has absolutely no mention of sexual harassment. Now fast forward to November 2013, Egypt was declared by the Thomson Reuters Foundation as the worst country for women to live in within the Arab world when compared to 22 other Arab countries, particularly as a result of its female sexual harassment rates. According to a report published by the United Nations Entity for Gender Equality and the Empowerment of Women, 99.3% of Egypt's female population has experienced a form of sexual harassment. And similarly, the United Nations Population Fund has declared Egypt as ranking 2nd in the world following Afghanistan in terms of this issue. Now, before I delve further into this presentation, I just want to mention that this paper introduces and uses the term weaponization to describe the intentional, advantageous, and defensive employment of sexual harassment as an instrument of power by lower-class men, state institutions, and women in Egyptian society. This term is used because it is the most representative of the conflicting and strategic employment of sexual harassment by different parties in pursuit of different outcomes. And the influence that this weaponization of sexual harassment has had on Egyptian society as a whole is an understudied attribute of the phenomena that strongly illuminates the nature of its production and perpetuation in Egypt. So essentially, my paper demonstrates that sexual harassment was variedly weaponized by 3 parties for different yet interrelated reasons. And specifically, it argues that it was partially produced by an ongoing class struggle, manipulatively reproduced by the state, and then strategically resisted by women to alter Egyptian society's gender-based power relations. So to start off, traditional suppression of sexuality, the silence that is imposed on victims regarding their experiences, the justification and social acceptability of the phenomenon's existence, the blame that is placed on women and their attire, and the state's censorship of media content in an attempt to publicly maintain an upright image of morality and decency, combine to create a culture that produces and tolerates and dismisses sexual harassment, which then operates as a silent and hidden discourse. Now, although all women are subject to sexual harassment, an interesting attribute of the phenomena that is rarely considered is its perception as a form of class struggle. An enabler of sexual harassment that's not really discussed is the influence of environments, aesthetics, and upbringing on the psychological being of males, especially lower class males, who specifically target upper class females when sexually harassing. In contemporary Egyptian society, the physical environment, social and economic relations, and day-to-day life in general combine to breed a culture of violence that is manifested in various forms, including sexual harassment. Studies on ways and methods to eliminate sexual harassment in Egypt conveys that 85.9% of the survey's respondents attested that perpetrating harassers were unemployed, 53.6% stated that harassers were workers and handcraftsmen, and 57.1% claimed that harassers were drivers. Other findings included that 50% of harassers were young adults aged between 18 and 29, and almost 40% were children under the age of 18. And that females in higher wealth quintiles are more likely than females in lower wealth quintiles to experience sexual harassment. In 2013, 16 million of Egypt's total population were reported to live in slums, and by 2015, the Egyptian Minister of Urban Development claimed that 50% of Egypt's urban population resides in slum areas. In addition, a study was conducted by the National Center for Social and Criminological Research in Egypt, and its results estimated that more than 2 million children lived in the streets of Egypt. Now, this kind of environment inevitably has psychological influences on lower-class members of society who develop anger and hostility towards upper-class individuals who grow up in completely contrasting environments, given the immense gap between the rich and the poor in Egypt. Essentially, this breeds a culture of violence that, as previously mentioned, is manifested in various forms, including gender violence. And although gender violence has always existed in Egyptian society, it has become more visible in the recent years, specifically after the 2011 uprisings, as economic, physical, and environmental conditions worsened as a result of the social and political turmoils that followed the revolts. And the reason that sexual harassment presents itself as a satisfactory mean of expressing anger and violence, whether deployed by children or older youths, is because in a supposedly conservative and traditional culture as the one prevalent in Egyptian society, women's sexuality is often the most hurtful form of violence. And as a form of class antagonism and opposition to their circumstances, lower-class males have arguably weaponized sexual harassment to express their social and economic frustration, attempt to escape class subjugation, and manifest their masculinity by humiliating and seemingly exerting dominance over women of higher social and economic classes. Now, given that the physical environment produces violence that is manifested in the form of sexual harassment, the Egyptian state then maneuvers this form of violence to its favor. Recognizing that underprivileged individuals suffer from repression, unemployment, and economic hardships, the state then intertwines its agenda to intimidate activists, including female activists, with these individuals' violent attributes by employing gangs of thugs that are more often than not grow up in the informal areas previously described to do undercover work for the police and powerful and basically instill a general state of fear. So it's important to keep in mind that this tactic is not only exclusive to sexual harassment. But essentially, these individuals are hired by the state to target, publicly humiliate, and sexually harass female activists who take part in demonstrations and protests. The women targeted in these protests, especially following the revolution, have included professors, medical doctors, lawyers, university students, and syndicate leaders. And by organizing their exposure to sexual harassment, the state has attempted to diminish these individuals' respectability and delegitimize their profiles. Similarly, members of the police institution are not only irresponsive to witnessed incidents of sexual harassment, but they also participate in sexual harassment and embody a mindset that justifies incidents of the phenomena by blaming victims. It's also important to note that police officers who engage in sexual harassment further violate women, as not only do they humiliate them, but they also authoritatively restrict them from reporting their incidents. And this is basically because by being able to use their power and connections to forge information, blame victims, and create scandals that women generally attempt to avoid, the position of police harassers has often intimidated women from reporting incidents against police perpetrators. Inevitably, these factors combine to create banality and ordinariness at various political and social levels, consequently sustaining a dismissive culture that persistently reproduces sexual harassment. And just as sexual harassment was advantageously weaponized by male citizens and state institutions to represent society's class struggle and the state's gendered policy, the phenomena was similarly weaponized by women who strategically resisted its persistence in an attempt to reconstruct society's gender-based power relations. Following the 2011 uprisings, the silence that was previously dictated by customary cultural and traditional norms was no longer accepted by middle and upper class Egyptian women who cooperatively began to voice their opposition to the phenomena by establishing anti-sexual harassment initiatives. These social groups, which are mostly founded and organized by women's rights activists, have risen to combat sexual harassment and openly condemn its normalization, therefore challenging the nature of sexual intimidation that harassment is supposed to impose on women. Although these anti-sexual harassment groups all strive to eliminate harassment's existence and persistence, and although they all rely on public presence and influence, they use different strategies to achieve their goals. So some groups focus on reporting incidents of harassment and encouraging victims to break their silence. Others play a more direct role in actively protecting women on streets and during demonstrations. And others attempt to influence bystanders and incite them to openly confront perpetrators and disrupt their comfort. Ultimately, however, the establishment and ongoing development of anti-sexual harassment groups permitted women to create a new field that shapes their opposition to the silence attributed to the phenomena, challenges socially constructed perceptions of the body and sexuality, and vocalizes their stance on social issues and gender-based violence. By doing so, these groups have essentially been able to alter public discourse, draft an anti-sexual harassment law for the first time in Egyptian history, and create an environment that is more hostile towards sexual harassment in general. And it is because of these women's opposition that we know more about the issue of sexual harassment in Egypt today. So by vocalizing the rejection of sexual harassment and its persistence, women were able to weaponize a phenomena that attempts to humiliate and restrict them from the public sphere to achieve the exact opposite effect, and to transform from silenced victims to influential actors that are currently renegotiating their social and political positions within Egyptian society. So in conclusion, this presentation has shown that sexual harassment has been variedly weaponized to manifest class struggles, state policies, and women's empowerment, and that it was partially produced by an ongoing class struggle, manipulatively reproduced by the state, and strategically resisted by women to alter Egyptian society's gender-based power relations. And essentially, this finding demonstrates that the evolution of sexual harassment from an invisible phenomena in 1997 to a widespread and normalized one in contemporary Egyptian society is a product of complex and deeply embedded cultural and historical processes.
Thank you so much, Nadine, for this fascinating presentation. I really like it a lot. You were pushing the idea that the state is complicit in the spread of sexual harassment in Egypt. How did you support this?
So I had a lot of statistics on the women that were targeted in the demonstrations and the kind of treatment that they received by the police. And essentially, the reason I was interested in this particular aspect of it is that it shows the state's attempt to reiterate that the woman's body is essentially a source of honor for herself and for her family members. And by doing so, and by trying to delegitimize the profiles of these female protesters, the state not only has attempted to sort of again, delegitimize what they had to say in the protests, but it also attempted to restrict their presence in the public realm as a whole by sort of maybe trying to have the influence of their male family members, or their rejection to the sort of experiences that they face in Tahrir Square or on streets in general, and so try to enforce their continued presence in the private sphere, for instance.
Something before, this reminds me of something you put in the webpage, just occurred to me. There were images that we saw in Tahrir of the harassers being delivered to the police, and yet we saw later on they were delivered to the police and the police let them go. The pictures exist now. This is what you can put on visually to prove that point, because it's a very good point. What evidence? The evidence is there, but the evidence is in the form of little films. But they were broadcasted to all of us as we saw them when we were watching by Jazeera in particular. Because I think if you go to the Jazeera documents, you're going to find those. I think it'd be perfect, as a lot we can get, and that's the evidence. That's what visually you can prove it. But you don't need the documents. It's actually there. It's happening right in front of us. The camera cannot lie, I guess, in that sense. I'm sorry, Dr. Asma, but I wanted to, if you can find this, it'll be perfect,
You mentioned the class struggle. One of the journalist. So was that
Anna Tahawi?
I think she immediately after do you think this part of the class or others someone like conscious of education doesn't have anyone here, the police isn't going to do anything for us?
I think this relates to my point on class. First of all, it's important to mention that all Egyptian women are subject to sexual harassment. So it's not only an issue that is particular to its perception as a class struggle. The only reason I pursued it through this particular lens is that it's something that hasn't been done before. To an extent, one of my findings was that again, the lower class males tend to specifically target upper class females who would be in other circumstances untouchable to them to a certain extent. So if we look at the incident that you mentioned through this lens, I think it would definitely fit into the way I've analyzed it through this paper, in the sense that, yeah.
You say that the lower classes are harassed on a daily basis, and that is not government control, while as organized upper class women, it's more government control. Just to follow up on
Again, it's in terms of the upper class women, it's not only government controlled, that's only one aspect of it.
Oh, they're also harassed, but I'm talking about organized and in demonstrations.
Yes, I think so. If we're looking at it in demonstrations in particular, then I think that might be the case. But I mean, lower class women were definitely harassed in demonstrations as well. It's not just that. But I think that the issue of targeting was absent in that case.
Yeah, I think we are talking about two different things here. First is that there is a culture of sexual harassment in Egypt, widely spread. I have a PhD student who has been doing participant observation on the streets with the young women in three different cities in Egypt, Sohar, Alexandria, and Cairo. And in all these places, even though they are different, this culture was there. And the only way that women could sort of escape that was that if they had a car, that they could sort of, because all these women had to sort of first, they always had to consider when going out how to sort of confront this phenomenon, because it is there. Meaning that you have to time when you go, where you can go, which areas are no-go spaces for women, and this is for all classes. But then only if you had your own car, then you could sort of escape it better than if you walked or used the public transportation. But then when we're talking about these particular days of revolution in I think the authorities or the police were simply using this method of disciplining women that was already there, which actually, I mean, if I compare to Yemen, if the police would have taken this kind of tactics in scaring women, that would have been met with popular opposition. I mean, people would be outcrying. But in Egypt, there is such a sort of prevailing culture that women should be careful when they go out, because it's up to her to choose why did she go there. And it's a sort of it's a responsibility that is put on women.
No, I mean, I definitely agree. I'm not sure about the core issue because faced, but I definitely agree that the core of the problem is in the mindset that justifies the harassment and puts the blame on the women. The way she's dressed, the place she's present in, rather than putting the blame on the actual harasser and treating the fundamental problem by putting the blame on the male instead of the female.
It's with a wider throughout the Middle East, and maybe Islam would like to step in and talk about this, and that is the culture of violence we see everywhere. I think that what we're seeing is are states that allow the violence amongst the the population to sort of take away from the edge of the state violence itself. That is, it's almost, sometimes I sit and think that maybe this is intentional. Let them, the state brutality comes through the police, etc., but they're really pushing and maybe allowing harassment, sexual harassment is a way of making the people themselves part of this culture and more accepting of the kind of state violence that we have. Maybe I'm reading too much into it, but what would a politician or a political science person say about that?
No, I agree with you. I think this also, this could be seen through Foucault's governmentality. The state is outsourcing a responsibility. Whether this is a responsibility or not, but they're outsourcing. Let's call it just a responsibility for the sake of the argument. I think, the state is outsourcing this responsibility to a group of the population to take on this responsibility, and the state just remains
Not responsible.
not responsible.
In other words, I'm not the perpetrator of violence in this
Exactly.
place, and maybe I'm not the only one violent. You're violent too, so you take care of those problems. And in that case, you leave the helpless. And by helpless, I must add also the poor animals in most of these countries. It's not just the children and the women. So basically, and even the young men. We're talking about. I think it needs maybe your subject. You should also blow it up and speak a little bit more of the wider context with the state and so on. We will hopefully for publication. We want to take that into consideration. What's happening statewide, and this culture of violence that seems to mean everything. It isn't just. It's not just against the women and so on. And even the women themselves today have entered into this field. As we showed in your paper, but now it's become really quite widespread that the women are answering back. And their interest is violent.
Yeah, well, speaking of the wider context, I think Nadine has did a great job in focusing on the relation between the gender or like the sexual harassment and the relation to the state, and how the state has been involved in that, especially in what we've seen as a horrifying scene to all of us in Tahrir Square when there was like this group sexual harassment incidents. But also speaking of the wider context, I would say it's not limited to lower class issue, but it's also, there is a whole lot of other incidents that maybe we don't happen to hear about in upper classes. When, for example, in companies, in universities, where maybe employees or professors use their power towards either students or their
Get away with it.
get away with it. And not only, but also it becomes sort of like a power imposition. For example, if we talk about the senior person in a company who would use this as to impose something on an employee, for example, for a return of a promotion or whatsoever. So it's also another layer of violence, maybe unspoken of, but that we don't hear about, because it doesn't happen in the streets. You could still be driving in your car with kids even, and you still get signs of harassment from driving cars driving nearby. So there's verbal looks. Maybe someone would just try to push you with the car. So you feel at a point that there is no shelter, there is no protection whatsoever for you as a woman in Egypt, even if you have your own car.
And also, if we talk about the state, the sexual harassment, by the state is not only exercised against women, it's also exercised against men. We hear about all these rape
cases in prisons against men as well. So it seems that it's not really violence targeted at women, but it's violence sponsored by the state against the populace or the public.
And I like the word outsourcing. May I use that? Because it is like جماعة الأمر بالمعروف. We call them جماعة النهي عن المعروف والأمر بالمنكر. So, but that is sort of outsourcing, and also usurping the rights of men who were the traditional supervisors. Now, you don't dress your daughter as you want to. You are not a man, we can rape you and just make you something not useful anymore. So taking that away and placing the state as the original guardian and then outsourcing it to certain people.
And not only that, even if in the police, for example, in Egypt, nobody studied the whole phenomena of Shurta. The person that does work for the Ministry of Interior, but is still, the policemen, for example, wouldn't consider him as a state, yet they outsource all the dirty job to this person. So he's in between. He's not really a civic employee. He's not really a state employee, and he's not really also a policeman. It's something in the middle that the state outsources all the dirty job to. And this is why, for example, recently they decided to just shut down the whole Mahad Umanaa Shurta, just to say that, well, we have nothing to do with that. These are all the Umanaa Shurta, and these are not really policemen. They don't really represent the state.
So I think that's why it is very important to study and document, what I could say, the institutionalization of the violation of the body. Israel, denied for a very long time the excessive and systematic use of sexual harassment against women and men in prison. To make a scene, invisible scene, but you hear, they show the daughter or the sister or whatever to the prisoner. And then beside a scene, there are a setup in which, they play like a theater with voices and everything, as if they are raping the sister or the wife or the mother or whatever. This is one thing, and it was documented by many prisoners, males and females. The other thing is that number one step, once you get arrested by the Israelis, is immediately, first thing, to ask you to take off all your clothes and stay naked in front of the interrogator, Besides, of course, there were some few cases of rape, not by individuals, but by tools, to some, Palestinian women. But these were enough evidence to speak about the institutionalization of this practice. In Egypt, I wish to put, the hand on something like this, because we see in the movies, for example, Marit Yaqubian and other movies, we see in the movies, we hear from, prisoners that, or we hear, for example, we read in the memoirs of many political prisoners about the rape of men in the prison. But we don't hear about the rape of women, it's not documented. So the issue is that I really loved your idea about the complicity of the state of this practice in the street. When we talk about, interrogation centers or prisons, these are invisible places. However, it is easy to document. You just need to interview the prisoners and some of the brave interrogators or policemen or whatever. But in the streets, you cannot have such wide-scale phenomenon in the streets unless it is institutionalized culturally and politically somewhere else. you know. So to find the connection between both needs to document it within the institutions themselves. So this is my.
Thank you very much.